The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh yay, oh yay, oh yay. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right. Good morning. We'll begin with, but have we changed the order here? Oh, no. Okay, we'll begin with the case of United States versus Abed, and Ms. Lee, we'll hear from you first.
Good morning, Your Honor. Christine Lee on behalf of Amar Abed. With the court's permission, I'm going to direct my comments, my argument today towards the what I consider to be the most important issue, which is the district court's refusal or failure to grant or even address Mr. Abed's request for a downward departure based on his military history and his documented psychiatric issues. Amar Abed came back from the war in the early 90s, a very damaged person. He went to the Middle East to represent our country, and he did so honorably, and he did so in many ways that were uniquely within his skill set as an Arab American. And in part because of that, but also just because of how awful war is, he came back with massive, massive psychological injuries. And those injuries are absolutely clear in the record, in the testimony of Dr. Pittman, and throughout all of his VA medical records, which I've provided to the court. Now, interestingly, he came back to Virginia and he committed a number of crimes. With one exception, we do not quibble with the government's account, nor could we quibble with the government's account of Mr. Abed's offenses, with one exception. However, those crimes occurred within basically a 2 to 4 year period immediately following his service in the military. And as Judge Urbanski pointed out during the sentencing hearing, even while all of these chaotic, violent events were occurring, Mr. Abed was repeatedly going to the VA, to the Veterans Hospital to seek help because he felt that he was losing control. But 25 years ago, the medicine and the medical and the scholarship was not such as it is today, where there's much greater understanding of post-traumatic stress disorder than there was then. They just called it Gulf War syndrome, and they primarily addressed it with medication, which in many cases made the person feel that they were in a fugue state. So he comes back, he commits a number of offenses. Clearly, there was drug dealing, there was all the shenanigans at the Pizza King and Tolly's Bar. There were brawls, there were fights, there were robberies, all involving other drug dealers and drug users. And then he was arrested, guidelines at the time, and mandatory consecutive 30-year sentence. So in fact, Judge Wilson, who sentenced him in 1997, had very limited window to work in. He had the guideline range that was properly calculated at the time to be 188 to 235 months. And he was required to impose a consecutive sentence of 30 years, consecutive 10-year sentence. Judge Wilson, hearing the evidence, did not impose the top of the guidelines for Mr. Abed. He imposed a middle of the guideline sentence for all of the I'll call them non-924C offenses. He imposed a sentence of 210 months. What's important for the court to know, and I don't believe Judge Urbanski ever even acknowledged this, is that at the time that Mr. Abed was sentenced in 1997, military service and psychological impairment was expressly disfavored as a consideration, as a relevant consideration in Chapter 5. Literally, the guidelines said military service is not ordinarily relevant. Psychiatric disorders are not ordinarily relevant in determining the guidelines. Consistent with that, Mr. Abed's attorney at the time did not, she mentioned his military record, but she specifically said on the record, we are not arguing that as a basis to give a lower sentence. That was what she did at the time, and it was consistent with the guidelines. Between then and now, the guidelines changed. The guidelines now expressly, consistent with common sense and again, scholarship and science, expressly state that it is relevant, that it may be relevant, that it should be considered. And in this case, and it's mentioned in Chapter 5 of the guidelines. Chapter 5 of the guidelines is a section of the guidelines devoted to departures. On that basis, Mr. Abed requested a downward departure based on his extraordinary military service and
Counsel, it's Judge Harris. Can you? I may have misunderstood something about the record. There was an express request for a downward departure at the second sentencing. It looked to me like the original sentencing memorandum asked for a within guidelines sentence. So was there a separate motion made later?
Actually, that's an interesting question. A departure, Chapter 5 is departures, 5H. So those are cited in the sentencing memorandum. But what counsel was seeking to have the court do is, because counsel was throughout the proceedings conceding that Mr. Abed had a higher offense role than his co-defendants. He was more culpable in the criminal activity than his co-defendants. I was seeking to have Judge Urbanski determine what sentence would correlate, and this is what he should have done under the law, correlate to that higher culpability and then depart back down to a guideline sentence. And that's
not a departure. That's just to take him out of the range relative to the others. A departure would have to be below a guidelines by definition. And there was no discussion of departure anyway by the judge, and no real argument about it. It was really, the question was a variance. He relied on a variance. But, the discussion was over 30 pages long, and there were questions and answers. And I thought where the judge was coming out was focusing on the conduct. And the conduct, of course, he reviewed in 2020 was no different than what Judge Wilson reviewed back in 1998. It's the same conduct. And he reviewed that, and he looked at what the others got 30 years. Mr. Abed suggested 312 months, not 30 years, 300 months. And Abed suggested 312 months, and the judge imposed 360 months, which was an upward variance. But I'm not sure it benefits our analysis to be looking at whether there was a departure requested in 1998 or whether a departure was requested here. In both places, they were not considered for differing reasons. Judge Wilson said, I don't need a departure because the government was asking for 595 months, and I think 570 months is right, and I can do that with the existing circumstances. Judge Urbanski didn't consider departure because he basically thought the variance in relation to the others and in relation to the conduct justified 360 months, which is an upward level of 4 levels, I think, on the guideline chart. But
if I may, Your Honor,
it's better, I think, to keep the criteria we're considering consistent with what was actually considered instead of getting into this departure business.
The court has actually pointed to what is really at the crux of the problem of what Judge Urbanski did in this case. Judge Urbanski did not, he considered this sentencing, which he used the word plenary resentencing, he used that more than once.
Well, that's what it is.
That's what it should have been. He did not actually conduct a plenary resentencing. He conducted, and to be fair to him, this was in February 2020, right in the midst of a number of First Step Act hearings that Judge Urbanski has held, where he decides under 3582 B or C whether to reduce the sentence from what it is. And through the proceedings, he, and with the invitation of the government, talks about this sentence as a reduction. And he specifically says the defense is arguing for a reduction. We weren't arguing for a reduction because 570 months was not the relevant guideline. Under Gall and under Rita, the district court has an obligation.
Yeah, but we're not talking
with
about
the guideline.
That. When it's a plenary, the judge was basically historically noting that he had 570 months and he's now getting 360. for the same conduct.
Actually,
And as you know, the guidelines are conduct oriented, and the instruction in the guidelines is to come up with a single offense level, and not to partition on the various charged offenses. That's shown in 3D and in 1B of the guidelines. So the initial sentence was 570 months for the same conduct. This one is 360 months for the same conduct. Now, obviously you have to take into account the charged offenses, but he still used a Molotov cocktail. He just didn't commit a separate crime for doing that now.
the problem, I'm sorry, and he was convicted of arson for the Molotov cocktail.
I understand, but
and he specifically got an enhancement for creating danger with that Molotov cocktail.
We shouldn't be arguing what the facts are. I mean, we should be arguing what your policy there was error, because I think the record's pretty clear as to what happened, and it was a plenary resentencing.
I agree that it was supposed to be. I disagree that it was. And the reason I disagree that it was is because the case law says in initial sentencing or in a plenary sentencing, the first step is to calculate the guidelines correctly and to use them.
And that's exactly what he did at the beginning of his sentencing. He said, I've calculated the guidelines. This is where I am. And he used the 3553 criteria and announced that too, and was applying that, and said he was going to create a variance based on those criteria.
It is true that
all right,
it is true that early on he said the guidelines were 188 to 235. He never mentioned that again, not once. Not once did he mention the guideline range again. Every subsequent reference to a specific time was 570 to 595.
Well, he was trying to explain why he was doing a variance. He started structurally. You just can't discount what he said. I mean, he said clearly, I'm creating a variance sentence. He created the guidelines correctly. He found the guideline range correctly, that's 188 to 235. And the only error he made was with respect to one count. He imposed 210 concurrent months, and later he corrected that right at the very end of the sentencing. But he did exactly that. It seems to me your argument has to focus on something other than the fact he didn't consider the 3553 factors, or he didn't begin with the guidelines.
He did not consider, he used the bench as a benchmark, as a starting benchmark, the sentence that was imposed in 1997. That sentence, in fact, is utterly irrelevant to his task today. And he specifically, in making his remarks about the sentence, states, this is why I'm not going to impose 570. He never says why he's not going to impose 235. Now, he does say, quote, there was a lot of crime. Yes, Your Honor.
Sorry, Counsel, it's Judge Harris. So I know the parts of the record that you're talking about. And there is a lot of reference to 570 as sort of a benchmark, but the government is asking for 570 or something like 570. So isn't it fair for the district court? I mean, you can understand it as the district court just explaining why he's not going along with the government's request.
Well, I asked for 312, but he didn't go along with that request or mention it at all either. But with respect to the government's request, I very much want to make the point, and they're going to argue it again today, that even if Judge Urbanski did not identify the reasons why he deserved 10 years more than the next person, that why such a sentence would be supported. But in fact, if the court looks closely at the pre-sentence report, every last bit of conduct is accounted for. There's no conduct that's not accounted for in the guidelines, including the 2-level enhancement for creating a danger. Yes, Your Honor.
Ms. Lee, I didn't mean to interrupt you there. You go ahead and finish if you'd like to, but if you would tell us how Ventura plays into your analysis, because I think that's a big part of the issue that we have to consider today, isn't it?
Ventura is a guideline case. The appellant in Ventura did not like where in the guidelines the sentence came out. The court does not have to explain with the same comprehensiveness and within guideline sentence and an outside of guideline sentence. This court has been clear that when varying upwards, the court must state specific reasons why the range is inadequate and how he got to where he got. Ventura, both before and after the sentences were within guideline sentences.
Right, but I'm talking about the sentencing package doctrine. I'm
not saying the sentencing package doctrine does not apply. I am not saying that. I am saying that it does not apply to the extent where, especially where from this record, a 30-year variance or departure would never have, I don't believe, have been, there's no legal reason for a 30-year departure. Why have a resentencing at all if the only goal is to recreate the old sentence? You've got to start with the current guideline.
How do you get a 30-year departure? There's no departure. Number one, it's a variance, but the guidelines was 235 and he went to 360, right?
Your Honor, I'm over time. May I answer?
Please.
I'm saying that if he had reimposed the 5.7 or 5.95, that would be a 30-year departure.
He asked the government clearly, what do you want? And the government said, I want the same sentence, 570.
Right.
But the court, when it announced what it was doing, it said, I'm going to create a variance. I start with the guidelines and 3.553 factors, and he started talking about that.
And saying those words is not enough.
Discussion related to various factors to consider the variance. And he talked about the rehabilitation, and he talked about the post syndrome, and he talked about, but he was very impressed also about that this was a very serious crime. He said one of the worst he'd ever seen. The government said the very same thing. And he talked about how the community was terrorized for 4 years. And so, and he talked about the relevance to the other defendants. And Mr. Abed asked for 312 months, recognizing that. And he said, I'm giving 360. And he explained why. But
he explained why he gave.
We're going to consider the sentence. We ought to be considering what the record actually says. And
I agree.
Okay.
May I?
You want to respond to that? Go ahead.
He explained why he gave 312 instead of 570. He never, 360 instead of 570. He never once explained why he gave 360 instead of 312. He didn't even allude to it. Yes, Your Honor.
Can I ask just a quick question? I know you're over time, but maybe this will help with efficiency. So you just said that you're not saying that the sentencing package doctrine doesn't apply here. And I understand that you sort of started your argument with this sort of procedural reasonableness questions about what happened at sentencing. But a good part of your brief was about how putting to one side whether this sentence was adequately explained, the district court simply didn't have the authority to impose this sentence, period. It violates the due process clause, violates the law of the case, it violates the ex post facto clause. But now you're saying you're not objecting to application of the sentencing package doctrine. So have you, are you continuing to press the argument that the district court lacked the legal authority to impose this sentence?
You know, that's a good question. Your Honor, all I can say is I submit on the brief on the ex post facto issue. I do recognize the importance of the sentencing package doctrine to make sentences fair and to effectuate the premise behind judge-controlled sentencing and the 3553A factors. I am saying that to use the sentencing package doctrine to effectively reimpose a sentence that, when I say it could not have been imposed back in the 90s, I'm not just talking about because the mandatory guidelines were mandatory, but if there had not been a 30-year consecutive mandatory, there's no way the government on this record could reach a 30-year upward departure on a Heartland argument or any other argument. So that's what I mean by could not have been imposed. And I'll reserve the balance of my time. Thank you.
All right, thank you. All right, we'll hear from the government.
Good morning, Your Honors, and may it please the court. My name is Jonathan Jones, and I'm here on behalf of the United States. Your Honors, I'd like to start with the procedural reasonableness question that counsel was spent quite a bit of time discussing. I think just to get right into it, if the question we're looking at is whether the sentence was adequately explained, I think looking at the record here, we can see very clearly what the court was doing and why it was doing it. He started by calculating the guidelines. That's on JA 4809. It's very clear that when he imposes a sentence, he starts by calculating the guidelines. And it's also very clear from the record at sentencing that he is considering all of the mitigating or Chapter 5 evidence that has been submitted by Mr. Abed. He repeatedly refers to the PTSD, refers to the military service. He speaks about the rehabilitation, and he's impressed with the letters that he's received. And he says very specifically on the record, and we've cited to this in our brief, that he's going to consider those things. And when he's imposing the sentence, when he goes through all of the 355-3A factors, he again alludes to these things, the PTSD, the rehabilitation, the military service. So it is very clear from the record that he considered all of those arguments and he took them into account in terms of the sentence that he decided to impose. In addition, it's also very clear why we did not end up with just a guideline sentence. On multiple occasions, he reversed to the severity of the underlying conduct. And we've certainly laid that out in the background section of our brief. And as the court has mentioned, what the PSR found was that Mr. Abed terrorized the community for 4 years. This is very, very serious underlying conduct. And the court recognized that and referred to that on multiple occasions during the course of the sentencing, during the course of imposing the sentence. He also recognized, as has been discussed here today, and I think as was acknowledged at the sentencing, that Mr. Abed was the most culpable of all the defendants. And so we have a situation where the court says he's the most culpable. This is extraordinarily severe underlying conduct. I mean, this is really, really terrible underlying conduct. But I'm not going to go as high as the government wants me to go, and that's because of all of this mitigating evidence that I've heard from the defendant. So what this court has explained district judges need to do for purposes of sentence is address arguments that have been made, and the rationale needs to be clear from the record. I would point specifically to Nance, where this court's decision in Nance, where the court explains that to the extent that it's clear from the record that the court considered and addressed arguments, and it's clear what the court's rationale is, that the court has adequately satisfied the sentencing paradigm laid out in cases like Gall and Rita. I think that's precisely what we have here. Your Honor?
Counsel, do you want to, can you respond directly to your colleague said, and I do see this in the record, and it troubled me to some extent, that although the court does start by laying out the guidelines, we're well into the transcript. It's been a long time since then, by the time the court really starts discussing this mitigating evidence. And it does keep discussing it in terms of, this is a reason for me to go down from 570 months. I'm reducing the sentence from 570 months. And it does never say, I'm going up from 235 months. It doesn't say that. And so it does seem that when the court does the real analysis, sort of applying fact to law, it has in its mind, I'm varying down. Do I need to be worried that this sort of the sort of myopic focus on 570 as a starting point might have had kind of a weird anchoring effect here and brought the district court to a different place than it would have ended if it had been focused on 235 and how far up it was going?
The short answer, Your Honor, is no. I don't think there's a problem, and we would disagree with the categorization that there was a myopic focus on 570. So the district court pretty clearly calculates the guidelines, and what Nance has said that it needs to be clear from the record, from the sentencing record, sort of the rationale and what the district court is doing, and that means that there's no magic words requirement. He doesn't have to specifically say anything. It just needs. Well,
no. I guess I'm not suggesting that there's a Nance problem here, a failure to discuss or account for the mitigating evidence. It's just that there are all these cases saying that the guidelines have to be the starting point. You're supposed to look at the guidelines, 188 to 235 months, and then explain why you're going over 235. And when I look at this explanation, I see an incredibly full explanation of why he is going under 570, but less. The loop is never expressly closed, that this is why this degree of upward variance is required.
So, Your Honor, I agree that he never specifically says at some point, I am going to vary downward for reason X. And I would submit that he does not actually have to.
Well, he varied upward. That's what I'm saying. He did talk about varying downward, but in fact, he varied upward.
Sorry, what I meant to say is that there's nowhere in the record where he specifically says, I'm going to vary upward for reason X. But I think when you look at the entire context, it's clear why he's coming above the guideline range. His repeated references to Mr. Abed being the most culpable and the severity of the conduct, I think, explain why he's coming above the guideline range. And when we look at the statement of reasons that was issued after the sentence was not appropriate. However, given the various mitigating factors that were discussed, the evidence that was given during the sentencing hearing, he was not going to go as high as the government recommended. And I think that pretty easily and pretty clearly reflects what had happened during the sentencing hearing. And so although he doesn't specifically say, I'm going to vary upwards because the sentence is because the underlying conduct is so severe, The fact that he speaks multiple times about the severity of the underlying conduct and multiple times says that Mr. Abed is the most culpable, and there's no dispute about that, it's clear why he's coming above. And he feels the need to come above the guidelines that he's calculated. But because the government is asking for 570 and making an argument as to why this conduct is so serious that we need a sentence in the range of 570 months, he says, I'm not going to go that high, and I'm going to come down from that, and this is where I'm going to arrive. He specifically talks about, on balance, this is the sentence that I think is appropriate. And the fact that he's talking about, Your Honor?
Mr. Jones, to what extent did the judge discuss the military service and the mental health issues with respect to the guidelines numbers? Did he ever make that correlation? In other words, talk about those issues that were foremost in the defendant's mind and relate them to the guidelines? Did he ever do that in the transcript?
So what he did in the transcript is he calculated the guidelines, and then he explained that he was considering those factors, that evidence, in terms of the sentence he would impose. So again, I would point to the court, this is JA 4809, and this is where he first calculates the guidelines. And then in the very next paragraph, he starts out by saying, the defense has effectively argued for a reduction based on the defendant's military service and combat service in Iraq. So he lays out the guidelines, and the very next thing he says is the defense has argued about military service, effectively so, and this is after he said multiple times that he's going to consider. So he doesn't specifically say this, the military service specifically impacts this part of my calculation, but what he does say is I'm calculating the guidelines, they're at 188 to 235, and I'm considering these factors in terms of 3553A and the ultimate sentence that I'm going to impose. And at the end, he says, on balance, I'm going to impose this sentence.
But when he's referring to a reduction, the defense asked for a reduction. What was he meaning there then in terms of reduction? Reduction from what?
Your Honor, the way that I would read that, so the defense has characterized their arguments in terms of a downward departure.
Right, no, I'm asking you, what does that mean? What was the judge referring to? Is it clear that when he's talking in terms of a reduction, what would be the reduction from? I mean, what would be the base that he is thinking about when he's talking about the reduction?
Given that Your Honor, given that the way that he has phrased it is the defense arguing for a reduction, I would correlate that to the defense's arguments that related to a downward departure based on the Chapter 5 elements that were discussed during sentencing. And so he's calculating the guidelines. He's saying they've argued for a reduction of the guidelines. However, at the end of the day, on balance, given all these factors, this is what I'm going to do.
You know, it seems to me, I don't know if this is a right reading, and obviously the discussion, it goes over a long period of time with the court of what it's considering and what it's not considering. But it looks to me that the last question that it posed to the government before it really began its sentencing, it's what are you requesting? And the government says, we're requesting 570 months. And the court said, I do not believe that a sentence in the range of 570 months meets or anywhere near meets the statutory obligations that I'm to impose here in this plenary resentencing. And so it seems to me that in the judge's mind, I don't know if this is a fair reading, but I'd like to have your comment. It looks to me the judge is trying to satisfy the government that it can't give the 570 and will not give the 570 when it reconsiders the 3553 factors. And so in that analysis, it is rejecting the government and explaining this is a new man, he's a different man, and we have new factors, and the judge explained that too. And so we're going to get these statements that he's not going to give the government the 570. But I'm not sure that the judge was focusing as much on what Judge Wilson had imposed, although he does historically relate to that, as he's trying to respond to the government. But I may be wrong on that. Judge Harris pointed out a couple of comments that suggested he was somewhat fixated with the 570, and he was, but it looks like he was because the government was pressing that number.
Your Honor, I think that's an absolutely correct description or characterization of what happened here. I think the government was pressing for 570, and I think the rationale of the court, I think, is relatively clearly divined from the transcript here and from what he said, that the government was asking for 570, and while he thought he needed to come above the guidelines, he was going to come down from what the government was recommending. And so, and we again disagree that there was sort of a myopic focus on the idea of 570 months, but he does refer to it multiple times. And I think he does so because the government is saying this conduct is so serious that you need to be that high. And he's telling the government, and he's explaining, I'm not going to go that high, and I don't think that's necessary, particularly in light of all of these circumstances that I've seen. But the fact that he's also continually referring to the severity of the underlying conduct and the culpability of Mr. Abed indicates that he still feels the need to come above the guideline range. And I think that sort of pretty clearly captures precisely what he's doing here. And that is an adequate explanation under sort of this court's precedents in cases like Nance and Carter. It's clear from the record what the court is doing and why it's doing it. And when we look at the statement of reasons, I think it just confirms that. It emphasizes and makes clear that what he was doing was looking at the severity of the underlying conduct and the culpability of Mr. Abed, coming above the guidelines specifically because of that, and then deciding not to go as high as the government wants to go and coming down from that 570 months that was the previously imposed sentence because of all of the mitigating evidence that had been shown. So he refers to 570 because the government is asking for it and because that was the sentence that Mr. Abed had been serving. So while that wasn't his starting benchmark, it was certainly something that was, I think, relevant to understanding what was happening in this case here. And the government was asking for the same thing, and he's explaining, I don't think we need to go up to that anymore. I don't think that's necessary. We're going to come down to a different range. And I think it's clear from the transcript, and we've, again, cited the relevant portions of the JA in our brief. It's clear that he considered all of those things, and it's clear why he decided that he needed to arrive on balance at the sentence that he wanted to arrive at. The conduct was so severe, and Mr. Abed was the most culpable, that he needed to come above the guideline range. However, he didn't need to go as high as the government wanted, and he didn't need to go as high as the sentence had been before. So it makes clear that he's coming down from that higher recommendation. Given all of that, Your Honor, we would say that the sentence here is adequately explained, and this court should, as a result of that, affirm. Unless there are additional questions related to the procedural reasonableness argument, I would want to move briefly, I think, to the constitutional issues that were raised by the defendant, by Mr. Abed as well. So there are two specific constitutional arguments that he raises, one related to the ex post facto clause and one related to the due process clause. Your Honor, I think that there's no problem under either. Beginning with the ex post facto clause, the relevant question, I think, is pretty clearly whether he could have received this same sentence when he was originally sentenced, and the answer to that is yes. Whether there could have been an upward departure even without the 924C at his original sentencing, just as there was an upward variance here. He's within the maximum penalties that are imposed for those sentences. That did not change. So the mere fact that Booker changed from a mandatory to an advisory paradigm doesn't create any sort of ex post facto problem. And this court has indicated that before in other cases. Excuse me, Your Honor, including, for example, United States versus Carpenter, and that's an unpublished case from 2006. With respect to the due process clause argument, there was a reference earlier to this court's decision in Ventura, and our position is that decision effectively forecloses any due process argument here. For there to be a due process problem, Mr. Abed would need to have received a greater aggregate sentence on all of the remaining counts than he received the first time, and that's simply not the case here. His original sentence was 570 months, and it came down to 360 months. So there's no way for there to be any sort of due process problem there. Your Honors, if there are no additional questions for me, I would cede the remainder of my time.
All right, thank you, Mr. Jones.
Thank you, Your Honor.
Ms. Lee?
Your Honor, it's important for the court to not only pay attention to whether Judge Urbanski says, I'm following the law here, I am going to consider the factors and consider everything I'm supposed to consider, but actually look at what happened in this case. where is the proof? Where is the evidence that he substantively considered the request for a lower sentence based on military service and psychiatric evidence? Now, everything he says about that service and about the disability is in Mr. Abed's benefit. He says, counsel has effectively argued it, and it's not lost on me that even while each one of these events was occurring, he was going to the VA and getting committed and he was seeking help. That's not lost on me. So we have extraordinary rehabilitation. We have 100% unrefuted military mitigation evidence. And he says, yes, that's awesome. And then he does nothing with it.
Throughout the sentencing, the judge says, I'm taking that into consideration.
But where's the proof of that is my question. Because
his statement simply says, I'm taking it into consideration.
Yeah.
Okay.
Ms. Lee, what was the judge required to do by way of explanation that he didn't do? I understand your argument about how he used the 570 as the base, or at least in some parts of the transcript appears to, but what was he required to do in terms of procedural reasonableness in dealing with the sentence other than, the service, other than acknowledge it, say that it made it, that he was factoring it in? What else did he have to do?
That's an excellent question, Your Honor. He's required to do two things. One is act reasonably based on that information. And the second thing is to adequately explain why he is rejecting our request for a lower sentence. In fact, we were requesting immediate release based on all of this evidence. The 312 months that we were requesting is 8 years above his guidelines. We were requesting, if he wasn't going to give him, if he wasn't going to consider himself limited by the ex post facto clause, we were requesting a sentence 8 years above his guidelines and higher than any other person in the case. So it makes no sense for the court to say the words, I'm considering the military service, and then do nothing with it, except he imposed the exact same sentence he would have imposed on a similarly situated person with no military service and no psychiatric mitigation. He
so
basically—
you're saying then the error is his failure to explain how he's factoring in the military service and mental health history with regard to the difference between 312 and 360.
And actually, and his error is also to impose a sentence that is just too high in light of all the evidence that he has credited. He has credited the evidence. We have not meaningfully controverted the evidence of the conduct. We have said that the conduct is accounted for in the guidelines calculation. And even after all that, if you think Amar Abed was such a, even though he got every enhancement there was, if you still think that he needs more time, bring it up to 312, but don't go further than that, because he had devastating psychiatric mitigation evidence directly relevant to his conduct at the time. He has an unblemished, he has a fantastic record in prison, absolutely unparalleled record in prison.
Okay.
And he served the country.
Let me ask you, I'm a little confused here, because if you were asking for 312, you were asking for a sentence that wasn't a downward departure, but now you're saying you were asking for a downward departure. So could you explain that? I'm a little confused.
And this is why the guidelines are no good, candidly, but that's another conversation for another day. The situation is this: I recognize Mr. Abed deserves extra time for what he did. I am saying that the departure should come down off of that.
Right, but if the guidelines are up to 235 months and you are effectively conceding that 312 is reasonable, you then maintain you were requesting a downward departure and the judge didn't address it.
It's a distinction without a difference, Your Honor. Honestly, I guess if I could have worded it in terms of do the 188 to 235, go down the chart in a way that reflects that the 5H factors. So go down 3 levels or whatever it might be, and then go ahead and add on your extra culpability, and you should come out at no higher than 312. It's a distinction without a difference as to whether you go up first and then come back down, or go down with a departure and then come back up because of the severity of the conduct. Either way, above 312 was procedurally and substantively unreasonable. Thank you.
All right, thank you. In the ordinary course, we come down and would greet counsel. And of course, what do we have? Somebody else joined in on this?
Ms. Paris, can you mute your, stop?
Ordinarily, we would come down and greet counsel, as you know, and this is a very important case. We told you, and we do now tell you, I appreciate your arguments and your briefs. They were well done, and we hope we can shake your hand in the future in person, but this will have to serve at this moment in time. Many thanks, and we'll proceed on to the next case. All right, the next case we have is United States versus Butcher. And Ms. Paris, you hear me?
Yes, can you hear me, Your Honor?
Yes, ma'am. And Mr. Young, can you hear me?
I can, Your Honor, thank you.
All right, well, let's proceed with the argument. Ms. Paris, we'll hear from you first.
Good morning, Erin McCampbell Paris on behalf of Gerald Boucher. May it please the court. This court should vacate the restitution and forfeiture orders entered below. No court can do what the district court did here. Because the district court exceeded her authority under the applicable statutes when fashioning her restitution and forfeiture orders, those orders are what this court has described in the past as an illegal sentence. As such, they must be vacated. With respect to restitution, the court based restitution solely on the defendant's ill-gotten gains. We don't know which particular restitution statute the district court applied when fashioning that order, but no restitution statute allows restitution to be imposed on the basis of ill-gotten gains. This court has explained in the past that restitution and forfeiture are distinct sentencing issues with separate statutory bases. The restitution statutes, whichever one would be considered, require restitution based solely on the actual losses.
Well, let's break it down if we could. It's easier to address it, the questions. Let's start with the restitution, which I think is, you have some stronger arguments for. Your argument is essentially that the restitution order, the amount was computed in a fashion that was erroneous.
Not just erroneous, illegal, or without the court acting in excess.
Well, there was an assessment. They had expert testimony. There was an assessment of the amounts. The court didn't accept it all, but there was a disagreement as to the amounts. But if there was error there, sure, that's a certain level of illegality. But the question I have is that when you have a disagreement over the amount, is that something that survives a waiver of the whole issue?
Well, what we have,
seems to me you would have to go, you'd have to probably point to something much larger, wouldn't you, to get beyond your waiver?
I disagree there, Your Honor.
Okay,
what we have here,
I'm glad to hear from you.
Okay, thank you. What we have here is the court said one thing and one thing alone with respect to restitution, which was that she was going to use the defendant's ill-gotten gains as the basis for imposing restitution. And this court has said no court can do that. Now, what I want to say that I think is very interesting here is that we have that one statement from her, and then we have the restitution order itself, in which she delineated the restitution or the loss that would be assigned to each of the various victims. Now, if we buy into her idea that this should be calculated based off of ill-gotten gains, and I don't accept that, but if we did, it has no correlation to what the government talked about with respect to ill-gotten gains with those transactions. And I want to draw your attention to one particular item that jumped out at me, although none of them are in the record anywhere. But if we look at what the government said in its forfeiture submission with respect to the Allen Avenue property, and this is at appendix page 406, it said that the defendants got $7,500 in total of ill-gotten gains or proceeds from that transaction. Then we look at the court's restitution order, and there are two banks there.
Counsel,
Chase and ABP.
I don't know if there's a problem with the audio, but Judge Keenan has a question.
Yeah, you can't hear me?
I can hear you. I can't see you. Let me see if I can adjust my. I can see you now. Yes.
Okay, okay, thank you. My question is, could the district court have imposed, consistent with the government's expert testimony, $1,012,000 as the amount of restitution in this case?
No, the court could not. I'm sorry, I didn't interrupt.
Why not? There was evidence. You're disagreeing with the theory of loss, but why could the district court not have imposed that? And if the district court could have imposed that, are we looking at a harmless error situation apart from?
No, we're not. So with respect to restitution, I think this is a very fascinating area of the law wherein there's really no one-size-fits-all methodology for calculating. You have to look at the unique facts and circumstances. So here we have the bank's actual statements as to what they believe they could have achieved if they either foreclosed on the homes at issue or worked it out with the homeowner and some other party to have a short sale. And we know that those were the only options available to the banks because on each of these properties, the homeowners had either defaulted or were behind on their mortgage payments. So based on that, we need to look at what the banks thought they could get for the properties through either a short sale or through foreclosure. And in each situation, they got—
What was wrong with the expert's testimony? What was wrong with the expert's testimony? Given to
a couple of things. So first, with respect to the Dara Lane property, the expert looked at what the short sale was in 2014 at a time when we were just coming out of the financial meltdown and said, I looked and I see that they refinanced this property in 2016, 2 years later, and that value minus the short sale is what I'm going to go with. But that's speculative, and we know what the bank itself thought it was going to get.
Did you make that argument to the district court?
Yes, we did, Your Honor.
Did you cross-examine the expert?
The expert was not put on at sentencing.
It was just a statement.
It was all done on paper. So about a week before sentencing, the government submitted its paperwork on that. We submitted an opposition brief, and then we had the sentencing, which was fairly rushed, as you can tell from the record, on the forfeiture and restitution issues.
And on the restitution issue, did you express your reasons for disagreeing with the government expert?
At sentencing, yes, we talked about the fact that there was no loss in excess of $3,000 of unpaid interest with respect to just.
So basically, you disagreed with the court's finding, which was supported. The $1 million was supported by the expert testimony. And you disagreed with that. The court didn't impose that. It reduced it by a substantial amount. But it seems to me that the whole debate
well, the court
is an argument that is encompassed in. I'm trying to focus on the waiver.
Yes, you're right.
And you clearly intended to waive anything connected with the waiver agreement, unless it was very fundamental, and that's imposed by law. But the intent of the plea agreement was pretty expansive.
Yes, Your Honor. So if you look at the language in the waiver, the defendant agreed to be sentenced for restitution under the MVRA, and the MVRA says that we only look at victims' losses. And the text of the plea agreement itself says that he agrees to pay whatever the victim's losses happen to be.
Right, but counsel, I guess, counsel, and then as you point out, the restitution order has a bunch of numbers under loss. And I agree with you, it's sort of hard to reverse engineer where these numbers came from, but you know, your claim is those numbers are incorrect, and that sounds like kind of a standard legal claim about how to calculate loss that would be comprehended by the waiver.
It's not that the numbers are incorrect, it's that the methodology, the court had no authority under the statute to use ill-gotten gains. And so then if we look at
but as you point out, these numbers don't even exactly correlate to ill-gotten gains under the guide. So, but how does that help you? These numbers don't make it look like the court did something other than just drop in restitution, than just conflate forfeiture and restitution. I don't know where these numbers came from, but they didn't come from that.
Exactly. So what I look at here is what the court said. And the court said she was going to use ill-gotten gains. No court can do that. That's why our argument survives the waiver, because the court acted in excess of her statutory authority. And then when we look and see, okay, let's take a deeper dive here and see what may or may not have happened, try to justify that in any way, you can't. There's no way you can justify what happened here.
You know, the line between the court erred in substituting, in conflating forfeiture and restitution, the court made a mistake and the court acted without authority. That's like a really fine line. Most legal mistakes could be talked about as a court not having the authority to do something. You don't have the authority to make a mistake. And I am just having trouble. Can you explain to me why this is not an ordinary legal error? Why we would think about this not as, I mean, in Harvey, we say it's an abuse of discretion. If you calculate the amount of loss by assuming that the amount of gain is a reasonable approximation, that's an abuse of discretion. You made a mistake. But it doesn't say like you had no jurisdiction to do that, you acted without authority. It just talks about it like it's a normal legal error of the sort that would be, you know, encompassed by a plea waiver.
So when I look at this court's precedent on the enforceability of waivers, a couple things jump out at me. One, Beck says it's something that no court can do in any case. We've got that here. Secondly,
no, we don't have that here. We don't have that here. It seems clear in this case that had the court said, for instance, I agree with the government's expert, the amount of loss is $1 million, she could have entered $1 million restitution agreement. This isn't a case where there's an argument, and I believe the defendant agreed to this in the plea agreement, that restitution for these crimes was going to be owed to these identified victims. This isn't a case where, if this judge had explained the numbers on that chart, that this would be fine. You wouldn't have an argument then that this exceeded her authority.
Except that her reason she stated on the record for the number she achieved was the ill-gotten gains, which no judge can do. So that's the distinction from what you're saying here. And that's why this case is one wherein the challenge survives the waiver. Again, if you look at this court's opinion in Blick, in that particular case, the court said that we know what an illegal sentence is when the sentencing error is one the defendant could not have reasonably contemplated at the time of the plea agreement. And here, there's no way my client could have contemplated that he would be held accountable for ill-gotten gains.
I'm sorry, can I ask you one question that does remind me of something, and I don't know if anyone will be able to explain this, but why does the plea agreement set $7,500 as the minimum restitution amount? Because yes. $7,500, as I understand what's going on here, that's the undisputed conceded minimum for the defendant's gain. But right. The plea agreement itself uses the defendant's gain as the anchoring point for restitution, which, as you point out, is supposed to be about loss. So it actually looks to me like a defendant could read this plea agreement and think, for whatever reason, it looks like we're going with gain as the amount of loss.
So what happened at the time of the plea agreement, we did not have numbers for restitution or for forfeiture, but we knew, our client knew, he had received the $7,500 payment. So we assumed that there would be some restitution number that likely could be more than that, but at the minimum, it would have been that because we knew he had taken that much out. So it's not a concession by any means that number that restitution should be based on ill-gotten gains. It was simply the only number that was available at that time, so we agreed that minimum.
Ms. Paris, what is legally erroneous about using the short sale amount as the starting point, as the forensic accounting did, and measure the short sale price, the difference between that and the refinance amount with regard to the two banks, and the short sale amount from the flip sale price with regard to the third property? What is legally erroneous about that? Because it seems you've got to show that that is legally erroneous in order to establish prejudicial error. Because
Your Honor, if the court could have accepted $1,012,000
under the government's theory of loss using the short sale as the base, and then determining the difference between that and the refinance amount or the flip sale amount, then you have at best harmless error unless you can show that the government's theory of loss is legally erroneous.
It's legally erroneous. And may I answer this question because I am actually over time?
Yes, please.
Oh, thank you. It's legally erroneous because the data the government used was not the actual losses. The restitution statutes require the government to demonstrate the actual losses. And so the short sale price was what the bank could achieve at that time with that property, with the homeowner in default. 2 years later, when we were much further removed from the economic meltdown that caused both Wall Street and the real estate markets to plummet, the property was worth more. So that's why the government's numbers were speculative at best. And the court, if it had adopted those numbers, would have been operating outside of the statutory requirements that the losses be the actual losses. And we know here the actual losses because we have the statements from the banks themselves as to what they—
Let me ask you this, just not to prolong this too far, but how do you distinguish review of an error under the restitution, which would seem to be waived by the agreement, and an error that is illegal and was not waived?
Well, I think that we are very much, we fall under the Broughton-Jones opinion of this court, which is that anytime the court is imposing restitution, the courts, because it does not have inherent authority to impose restitution, must do so under a statute, and the statute at issue, it must apply properly. So we are akin to the Broughton-Jones case where the court broke from the text of the statute and imposed restitution for a victim for a crime for which there was no conviction.
That doesn't quite focus in on what I'm trying to get at. Let's assume you have error, that the district court applied the statute incorrectly.
Yes.
The plea agreement wants to waive, it looks like, any issue relating to sentencing, including restitution. In other words, you have agreed to the plea agreement, and you agree the minimum amount of $7,500, but the court can determine the amount. And you've waived any issue with respect to that. Now the question is, it doesn't have an exception in there like you're talking about. So the question is, you're challenging what the district court did with respect to restitution as error. But why isn't that waived?
I don't think this court has ever held that there are any particular words or formation of—
Oh, I'm asking you for your idea. Where do you draw the line between an error that is outside the waiver agreement and an error that is encompassed by the waiver agreement?
Okay, so we make several challenges here. If you look at, for example, the fact that the court didn't identify a restitution statute and the record's unclear, I think we can concede that that's something that's probably covered by the plea agreement. But our lead argument, our big ticket item, is that the judge used ill-gotten gains. And that's something that no judge can do. The plain text of the statute doesn't allow the judge to do that. And this court has said it's not allowed. So that's why that particular error is one that would survive and allow us to argue that on challenge.
What if the judge entered the $1 million figure?
Pardon me?
If the judge entered the $1 million figure, would you have a case?
I think there our argument would be that it was not based on the actual losses. The statute, the restitution statutes require the government to prove and the courts to administer or fashion restitution based on actual losses, and that wasn't there. So we would make the argument. I don't know how you feel about it, but that would be—
Yeah, Ms. Paris, there was evidence of loss, though, from the forensic accountant. Now, you're saying that just because the property went up 2 years later in value, that can't be measured as loss, but the short sale wouldn't have occurred, and the approval of the short sale wouldn't have occurred except for the scam in this case that took place. So why wasn't that I mean, you don't have any contrary evidence in this record that says that this methodology is unsound.
So what would have—
So it seems to me you're asking us to speculate on what market conditions may have been and what somebody could have sold the property for if they weren't involved in a scam.
What we know here, and what I think distinguishes this case from many others, is that in each situation, the homeowner had already defaulted or was near default. So the bank either could have foreclosed on the home, and the banks we know said that their amount of money they would have received in a foreclosure sale was less than what they would have received if they'd gotten a short sale, or they could have sold the property at short sale. This is not a situation where you and I put our properties on the market and they sell. This is a situation where a bank has to make a choice. So if the bank, if our clients had never been involved with these properties, ultimately the banks would have had to move forward on foreclosure. And if they had done that based on their own information, they wouldn't have gotten as much money as what they did here. So that's how we.
Counsel, can I just, your answer to Judge Niemeyer's question, sort of how do we know, what line are you offering us between a regular error and an error that can't be waived? And your answer was sort of like, well, no judge can do this because you're not allowed to do it. So no judge could have done this, but that describes all legal errors. Judges aren't allowed to commit any legal error. And so I'm not, and then it sounds like you would make the same argument had the district court judge entered the $1 million order. You would say, well, that's not based on actual loss either. And under the statute, it has to be based under actual law. So you have exceeded your statutory authority. And I'm just not finding, I find this question very difficult. I want to be honest, but I haven't heard you yet give us an answer for why this error falls on, is not just a regular error, the kind of error that no judge can commit. No judge can commit an error. Why, if this is not covered by the waiver, why any objection to the amount of restitution as not actually being the amount of loss would not also fall outside a plea waiver? Or maybe you think they all do fall outside a plea waiver.
Well, look, I mean, yes, in my opinion, I think we've made arguments here. There are several different arguments we've made. The big ticket item, the one that absolutely, in my opinion, without a doubt survives waiver, is that the judge based her restitution order on the ill-gotten gains and that alone. And what this court has said in the past, when trying to draw the line.
Focus on what Judge Harris just asked you. What is the standard, not your argument, what is the standard for distinguishing between waived error and non-waived error?
So if it was simply that the judge, for example, hadn't identified a statute or that there was a miscalculation of some sort, we couldn't bring that challenge because we had waived that. But what we didn't anticipate, and this is where I think we crossed the line here, and it is a fine line, but we crossed the line when it's something that no defendant could have anticipated at the time of the plea. So for example, I'll give you another example. Our client agreed to be sentenced under the 3553A factors. Well, at sentencing, the judge came in and applied Mississippi law. I mean, that's something he never could have anticipated. Just like here, he never could have anticipated that restitution would be calculated based on ill-gotten gains, because we all know that the statutes don't permit it and that courts don't have inherent authority outside the context of those statutes. So the court was acting without authority.
Okay, I think we get the gist. All right, why don't we hear
Thank you.
from your colleague? Yeah. Mr. Young.
Good morning, Your Honors. May it please the court. Let me jump right in at the colloquy between the court and my friend on the other side, which is what's the line? And let me offer you the government's view of what the line is, and then let me offer some examples that I think illustrate that. So we think the line is the line from Thornsberry. The court has distinguished between claims of error that the court did something illegal, which it defined as beyond the authority of the district court to impose in all instances, and something that was done in violation of law. Those are the two categories. In our view, Your Honors, for something to be illegal and therefore outside the scope of the appeal waiver, it has to be illegal in all instances and fact patterns. And the classic example of this from this court's jurisprudence is Broughton-Jones, right? The court has said repeatedly that Broughton-Jones error is this kind of error. That was a case where what this court held was that in a perjury prosecution, where the offense was lying to a grand jury, as a matter of law in all instances, that kind of offense did not create third-party victims. So imposing restitution for that offense is unlawful in all instances. So let me apply that to the facts here. And I think it's very important to break apart two different species of error claim that my friend is making. The first kind of error that my friend describes is a Harvey error. That is that the district court impermissibly substituted gain for loss. Here's the line I would draw, Your Honors. If the district court said it was doing that in that way, I think it would be illegal and outside the scope of the appeal waiver. But in order for that to be true, I think the district court would have to have said something like, I disagree with both the government and the defendant. My view of this case is that the correct loss amount is 0. But for reasons of fairness, I don't like that. So I'm going to substitute gain for loss. Under the restitution statutes, you can never do that in any case. And if that's what the district court had done, then I think I would be conceding that that was illegal and outside the scope of the appeal waiver. But Judge Keenan and Judge Niemeyer, I think your framing is exactly right. What the district court was confronted here with was two different theories of loss. One articulated by the defendant in his sentencing position paper, and one articulated by the government and the government's financial expert in their sentencing position paper. And on our view, the best reading of the record is that the district court didn't agree with the defendant's argument that the loss was 0, and for whatever reason, discounted very far down from the government's $1 million figure to a figure that matched the forfeiture figure. Once we're in that world, we're just disagreeing about how the district court did what the restitution statutes tell it to do. And once we're just having a disagreement about methodologically how you calculate loss, it's a regular kind of error that's going to fall within the scope of the waiver. And the best case I have for that proposition is Blick, which is a case that my friend on the other side mentioned a moment ago. Blick comes extremely close to saying this expressly in footnotes 3 and 12 of that opinion. Blick was a case that involved embezzlement from corporate accounts. And the defendant had this theory that he pressed both at the district court and before this court, that because of corporate ownership rules, you could kind of embezzle your own money without actually harming anyone. And at footnote 3, this court said in Blick, notice, this is not a clear error challenge to the district court's findings, it's just a theory of loss. And then at footnote 12, and this is where I think it's critical, the court says, we do not view the defendant's theory of loss argument as any way implicating our decision in Broughton-Jones, period. I think the best way to read those two footnotes together is that when you're just disagreeing about a loss calculation methodology, it's not a Broughton-Jones species of error. It's not a claim of illegality. It's not a claim that the district court did something it was never authorized to do. Yes, Your Honor.
Mr. Young, your opposing counsel, Ms. Paris, is saying that the district court was attempting to tie restitution to ill-gotten gains. But I think the actual language that the district court used was, she said it would make no financial difference to distinguish between restitution and forfeiture. Assume for a minute we didn't have the appeal waiver. How would that be a justifiable explanation for restitution, that it would make no financial difference?
Let me put all of my cards on the table, Judge Keenan. If there were not an appeal waiver in this case, I would have very tough sledding on direct appeal. Because on direct appeal cases without waivers, and I've sort of read all of them, the court is pretty specific about you need to explain how you got to loss, you need to explain why you made a preponderance finding of loss, and you need to do so in a way that's amenable to our review on appeal. So you have to explain what you were doing. And so the gap between the $1 million figure and the figure that was imposed, I think might be difficult for me to defend. I will say this, I am aided enormously by page 444 of the appendix, because what happened in this sentences hearing is the district court initially announced that it was going to go with the $7,500 figure. And the attorney for the government in the moment, trying to secure recovery for the victims, said, well, if you're going to go with gain, these two fraudsters gained much more. But then at page 444, the prosecutor made absolutely certain that there was no doubt on this record that the government was committing Harvey error. I mean, the prosecutor says, let's back up a second, Your Honor. Restitution is actual loss to the victims. Forfeiture is ill-gotten gains. They are two different things. Sometimes they overlap, sometimes they don't. And we have offered you a theory of why the loss is what we think it is in this case. And on that kind of record, I just don't think my friend's argument that the district court was committing straight up Harvey error has much traction.
Wait, counsel, wait, counsel, for me to agree with you, are you saying, do I have to think that what happened here is not that the district court used use the forfeiture numbers and just drop them in as the restitution numbers? I have to think that what happened is that the district court started with $1 million and worked down and kind of by coincidence ended up with the same amount as for, is that what you're saying?
I don't think so, Your Honor. And the reason I say so is I don't think species of sentencing explanation errors survive an appeal waiver. So let me put it this way, because I've sort of thought about cases that I think would be really difficult for me in preparation. Imagine the defendant came forward in a case and said, we think the loss is X dollars. And the government came forward and said, we think it's 10X dollars. And the district court, without explanation, said, I think it's 1,000X dollars. I think that would be a tough case to defend even with the waiver, because you might really wonder whether the district court had any hook to calculate loss on in that context. But because here we're sort of within the range offered by the parties, I just don't think that kind of thing is a concern.
What if, in your example, the district court came in and said, I don't like either of those, I'm going to go with the same amount as forfeiture. I'm going to go with gains. Because that's what she said.
I think she would have to, again, because there's not a species of sentence and explanation error, I think she would have to actually say that she was committing Harvey error. I think she would have to say, I think the loss is 0, but I'm going to use gains anyway.
Well, let me ask you,
that's not hard. That's not Harvey error doesn't assume that the loss is 0. Harvey error just, you don't have to say that to commit Harvey error. What the court said in Harvey was not, I think the loss is 0, but that's okay, I'm just going to go with the amount of gain. The error in Harvey is simply calculating loss based on gain. And how did the district court do anything other than that here?
Judge Harris, I think that's right. And let me rephrase and then offer an example that I think might clarify my position. In order to be illegal, you have to be outside the scope of what the statute tells you to do. So when I use the phrase pure, unadulterated Harvey error, I think you're right, that's a little imprecise. What I mean to say is the district court says expressly, I think the loss was 0, but I'm going to impose restitution anyway. We think that's outside the scope of the waiver because it's flatly illegal, because the restitution statute doesn't allow you to do that. Let me offer you an example of why I think an actual Harvey claim is going to be encompassed by the waiver. And this comes from personal experience, but I think it's helpful. I once litigated a case in front of a judge where my argument was, Your Honor, this is the kind of case where every dollar lost by the victim flowed into the pocket of the defendant. So you are not committing Harvey error by setting restitution and loss at the same figure. The district court judge agreed with me. That was a case with an appeal waiver. I don't think you could get out from underneath that appeal waiver on appeal by challenging that methodology.
Well, this is the question I was going to ask you. It seems to me in most economic situations, let's take a person uses a counterfeit $20 bill to buy a widget. The loss to the merchant is $20 because it was counterfeit and the money was no good. The gain to the defendant is $20 because he got the benefit of a $20 purchase. So the gain and the loss are the flip sides of a transaction where they're the same. Now, it doesn't always have to happen that way. And this case may be a good example where it doesn't happen that way. But economically, I don't think we should call it taboo to be looking at gain to try to determine what loss was, because oftentimes in an economic transaction, the gain does measure the loss.
I agree, Judge Niemeyer. The Second Circuit in a case called Zingari sort of has articulated a whole line of precedent about this exact issue, and I think that's exactly right. Let me turn, if I can, to the other species of claim. My friend also argues because the restitution statutes only permit restitution orders for loss, if I come in on appeal and say the true loss amount was 0, I'm necessarily outside the scope of the appeal waiver. We think that's wrong for a number of reasons. The easiest explanation, perhaps, is this court's opinion in Roger Day in 2012. That view, sort of at a deep level, relies on the idea that the maximum sentence for purposes of restitution is like a stepwise function, where if there's $500 of loss, the maximum sentence is $500. But if there's $1,000 of loss, the maximum sentence is $1,000. And if that were true, restitution would be subject to Apprendi rules. And this court said in Day it's not. The court said flatly, the maximum amount of restitution is always indeterminate. That's why Apprendi doesn't apply. So that species of argument just doesn't have any traction. And then we're left kind of where we were in the colloquy while my friend on the other side was giving her opening argument, which is all of these short sale scenarios and mortgage fraud type scenarios are always going to be extremely fact specific and are going to be amenable to different theories of calculating loss depending on how one views the transactions. And that was true in Ritchie, which is a case that's cited in the briefs about mortgage fraud. This court had a case called Stone in 2017 about short sale fraud, like this case. And reading those opinions, the court gives district courts a fair amount of latitude under the abuse of discretion standard to adopt a loss calculation methodology as it sees fit. And in our view, that's sort of the best reading of what happened here, is that the district court, while perhaps not explaining itself to any great degree, was calculating loss off of the two different methodologies presented by the parties in circumstances where the government made absolutely certain to put on the record, restitution and forfeiture serve different purposes. So at least theoretically, you have to disaggregate them. So that was said out loud at the sentencing hearing.
Anything else?
No, Your Honors. I will rest on my brief and encourage the court to enforce the waiver and dismiss the appeal.
All right, Ms. Paris, you have some rebuttal.
Yes, Your Honor, thank you. I just want to hit on a couple of points that my friend mentioned. The first, he said that the way we know where to draw the line is that we look and see, is this a situation where in all instances the court could not do what it did? And that's what happened here. There is no situation where a court can use ill-gotten gains, the stated basis and the only stated basis.
You know, economically, I didn't want to get into this, but economically, the way the banks treat these transactions are sometimes just choices to be efficient for other purposes, to have their books read this way or that way. And it depends on how you calculate losses, whether you turn over a property and forego the deficiency judgment in one manner or another could be define a loss. And I think it's a very complex problem whether the gain and the loss are going to match. They're probably not going to match, simply because the bank has totally different motives and needs with respect to its books. But you would have to define a beginning point for the bank to decide what a loss was. And one accountant could start with the notion that the full repayment of the loan is the beginning point. And then you could argue, well, it took less than the full face value of the note. Was that because of the fraud, or was that because of the market? Or was that a combination of both? Now you have expert opinions coming in and trying to define those things. I think it's even more complex than that in this case because of the banking regulations and how they book these things, these short sales. And so I'm simply suggesting to you, just using the word gain to determine loss doesn't get you very far in my judgment, because I think gain can measure loss so long as you understand what you're doing. But normally you want to call it loss because you're looking from the bank's point of view. It's hard to put these other cases as a direct match. And what I come down to is here we had evidence from an expert who said the loss was $1 million. You had a judge that said, I'm going to reduce that to $250,000. Now, the question is, did the judge any reason or basis to reduce it from $1 million to $250,000? And the answer probably is no. But getting back to Judge Keenan's original question, why isn't that absolutely harmless if it could have put in $1 million? Anyway, that gets into some of the discussions, and I think you and I could go on for quite a while exchanging ideas on this and on the losses, but we would also have to understand the bank's books and what the bank was doing and how it treated these transactions. And that's a complex thing because the banks accepted short sales for its books because it would receive more money than in a foreclosure. And it would also then have to carry the loan as a bad loan. And all of those things have value. And so the question is now, when the bank chooses to do this, being induced by fraud to do it, do you take all of that loss, or you take just what the market would not have accomplished, or what the bank otherwise would have agreed to, even in a non-fraudulent situation? Very tough.
I agree that it's a complex set of facts here, and that generally these real estate transactions are that way. The one thing we do know when we look at the record, the government said that under no circumstances would these banks have ever gotten the full value of those loans. The government.
That's speculative too. That's if the market popped up 100% the next day, then the houses where they would have gotten all their money. I mean, this.
Okay, but the government bore the
avoid the economic difficulties and realities by just positing one scenario. There are a dozen scenarios that could be posited. And in this type of case where the defendant was manipulating the economics and playing the market, it's very difficult to decide whether his gain is the bank's loss. The bank may not book it as a loss, but that's for other reasons why the bank doesn't want to book it as a loss, but for regulatory reasons. So
but we have to go with the record we have, and the record we have, we don't know why the bank did what it did.
It seems to me, on the record we have an expert who looked at this and concluded $1 million was the loss.
And we requested a hearing to challenge that expert, and we were denied the opportunity to do so. So
that's okay. That's error. But it seems to me that that error is, when you have evidence in the record, that error is probably an error that was waived. Now the question is, okay, the judge creates another error by giving no explanation from going down from $1 million to $250,000. But then the question comes is, how's that hurt you? And was that waived anyway? Is that just part of the calculation?
So when looking at this record, there should be no confidence in what the court did below. There were both big and small errors. We brought as many of them as we recognized to the court's attention, but there are two big ticket items that can't be ignored. One, she used ill-gotten gains to calculate restitution. That survives the waiver. Two, she imposed forfeiture on my client.
The ill-gotten gains may or may not be correct. We don't know. Me? The ill-gotten gains may be a correct measure of loss. That's my whole point economically. We don't know that for sure.
We don't know that, and this record doesn't demonstrate that. So we have to go off of this
expert opinion.
Which, again, there's other evidence, the bank's actual statements about what they expected to get, which would tend to undercut anything the expert had said. Now, setting that aside, I also want to touch on forfeiture and why I believe our forfeiture argument survives the waiver as well, which is that my client agreed to forfeit ill-gotten gains that he personally acquired and or benefited from. He was ordered to forfeit $220,000 that he never personally gained or benefited from. And we know that because the government conceded it.
Wasn't he an owner of that bank account?
Yes, he was. But if you look
and the money went into the bank account and it's his money.
And it all went to the co-defendant.
The fact that his colleague ran off with it is something else. But that's a little bit like taking home the ill-gotten gains. He takes $250,000 home and puts it on his chest in the dining room. And
no, it's not akin to that.
During the night, a robber comes in and steals the money. And so
it's not akin to that. Our facts are better than that.
Let me just get finished with a question, then you can respond.
Sorry.
But the point is, he got the $250,000, or $227,000, whatever it is. He got that money. He never used it. He had total access to it and as much control as the other man had. The other man ran off with it. But the fact is, it was his money and it was put in there. I don't know how you can deny that a joint bank account where he had as much control as his partner to that account, why that isn't his money.
The Supreme Court actually gives us the answer to that question as to why that's not his money. When they give the example where they talk about the farmer who decided to sell marijuana, and this is in the Honeycutt case, and the farmer hires a college student to sell his marijuana to college students. And they talk about the fact that the farmer gains and personally obtains the proceeds of college students. The college students pay that distributor. The distributor then returns the money back to the farmer. The distributor is not to be held accountable for those proceeds. The Supreme Court says that in Honeycutt. So that's why we know our client did not personally obtain or benefit.
Ms. Paris, we're talking about a bank account here. And this is what the First Circuit was talking about in that Cadden case, wasn't it? And saying Honeycutt does not apply in the situation of a joint bank account because you control the asset.
In that particular case, I believe the co-conspirators were a husband and wife, and the bank account at issue was a family account. And the defendant conceded
why would that matter if there was a joint account?
Because the defendant,
and the analysis was that if you actually acquire, I think that's what the court said, you actually acquire the money in the account if you are a joint account holder. What's wrong with that analysis?
Because in that case, the court explained that the defendant conceded that he actually benefited from that account because it went to the benefit of the family of which he was a member. So he actually got the personal benefit from that joint bank account. My client did not benefit a penny. I mean, the government conceded that argument. They also conceded not only that, there were no intangible benefits to him. If he was unable to make use of that balance to, say, for example, use it as collateral for a loan for something else, or get better credit, etc., he made no tangible or intangible benefits personally from those funds. So the cases that talk about—
Can I ask you a question about the forfeiture question? Because again, I think I'm quite possibly misunderstanding something. So your argument is about why the joint bank account was not obtained within the meaning of the statute. But why doesn't, is the plea agreement itself, couldn't the government rely just on the plea agreement to support this forfeiture? Even if it wasn't covered by the statute, the defendant does agree to forfeit all interest in any fraud-related asset that the defendant owns or over which the defendant exercises control directly or indirectly. So if I thought the bank account fell into that, would it matter anymore whether it was obtained within the meaning of the statute?
Well, I think what you're probably latching onto is the indirect, obtaining it indirectly is my guess.
Well, I guess, can you just answer my question? Like, if it falls into this, does it matter anymore whether it falls within the statute?
No, I mean, I think
Okay.
I read Honeycutt and this court's opinion in Chittenden to require the defendant to personally benefit from it. So just falling
in order for the statute to authorize the forfeiture. I guess I'm asking you just a very fundamental question. I had assumed that even if this, let's assume hypothetically, the statute doesn't authorize the forfeiture, the defendant could still agree to give it up in the plea agreement, right?
Yes, I suppose you could agree to, forfeiture that's outside the context of what would otherwise be permissible. Right. Yes, but we didn't agree to that here. We agreed to be to forfeiture under Section 982, and that was.
Well, you agreed to forfeit anything over which he exercises direct or indirect control.
Yes,
is what you agreed to. Okay.
If we look at the Honeycutt example that the court gave on the farmer and the college student dealer, the student, which is our, pardon me.
I think we understand.
Okay.
Yeah. We'll end this case, and I do want to thank you for your argument. We normally shake hands, and we have to greet you through the streaming, which is not that great, but it'll have to suffice. Thank you for your arguments, and
thank you very much.
If it's okay with the panel, should we proceed, or should we take a 5-minute recess? Okay.
Fine to proceed.
Yes.
For me?
Yes, fine to go ahead.
Okay, we'll proceed to the next case. Frank and Ms. Mertz, are you here?
Yes, I'm here.
And Ms. Grimes, can you hear me?
Yes, Your Honor.
Can you hear me? All right. Ms. Mertz, why don't you proceed?
Thank you, Your Honor. Good morning, judges. May it please the court. My name is Cadence Mertz from the Office of the Federal Public Defender on behalf of John Frank. Your Honors, a lot of ink has been spilled on the issue of the MVRA, the Mandatory Victim Restitution Act, and ERISA, and I will address that argument first, but I also will attempt to get to the other two arguments that we raise. One is the extent of Mr. Frank's access to his ERISA funds, and the third argument in our brief, which is about the limit on garnishment of certain types of funds under the Consumer Credit Protection Act. Your Honor, it's our position that the resolution of the first issue in this case, whether or not the government can actually garnish funds sitting in an ERISA account, is a fairly simple and narrow question of statutory interpretation. It is based on well-founded principles that this court has a duty to read two statutes that may appear to be in conflict, to read them harmoniously and to find a way to harmonize that. In this case, we have two widely different statutes. We have a statute that makes restitution for crime victims mandatory, and we also have the Employee Retirement Income Security Program, which is ERISA. And that statute is aimed at protecting funds for pensioners upon their retirement and to ensure that they have a stream of income later in life. These statutes on their faces appear to have very little to do with one another. And in fact, the MVRA says nothing about ERISA. It does not clearly repeal ERISA. It does not expressly repeal ERISA. Instead, what the government argues for is an implied repeal. And implied repeals are strongly disfavored under the law. An implied repeal is to be regarded only if it is actually necessary to make the later enacted statute work, and only if the two statutes are, to quote, positively repugnant to one another. Yes, Judge Harris.
Counsel, I guess I'm not really understanding why this is an implied repeal case at all. I mean, this implied repeal is you have these two, as you say, totally inconsistent statutes. You have no idea which one is supposed to apply. So we infer that based on the chronology, Congress in the second one repealed the first because it would have known about the first when it enacted the second. Nobody is arguing for an implication here. The argument, as I understand it, is we know exactly what Congress wants you to do. We don't have to infer anything. Congress said in the MVRA that notwithstanding any other federal law, this is the statute that governs. So this just looks like a pretty straightforward statutory construction case to me. And indeed, when the Supreme Court deals with these notwithstanding clauses, it doesn't talk about repeal by implication. It just says that those show Congress's clear intent that it wants this statute to prevail over any other, supersede anything that might be inconsistent.
Thank you, Your Honor. Your Honor, the reason that it's an implied repeal here is because although the MVRA uses the broad language of notwithstanding any other law, it does not expressly address ERISA, an entirely different statute. It
doesn't have to. That's the Supreme Court has said once you have the notwithstanding clause, that's how Congress makes manifest its intent that this provision should govern in the case of any conflict.
Your Honor, that implies that there is a conflict to begin with, and our position is that there is not a conflict here, that these two statutes actually can be read consistently with one another. The MVRA is a later enacted statute that makes zero mention of pension funds, and it is taking the notwithstanding clause too far to read it to repeal a very long-standing and widely regarded provision of an entirely different statute. This comes particularly only 6 years after the Supreme Court said that if Congress is going to make exceptions to the anti-alienation provision of ERISA, it's going to have to do that expressly. And so not only does the notwithstanding clause here not bear that weight, but it also comes in the context of the Supreme Court having actually spoken on the issue that it needs to be a much more explicit description of what is intended. Further, the MVRA does not address the vagaries of ERISA, which is a very complex statute and has lays out a scheme for protecting pensioner funds. That in putting that sort of weight on the notwithstanding clause, one has to conclude that Congress sort of vaguely and without any kind of express discussion of the ERISA scheme just upended a key piece of ERISA for the purposes of the MVRA. And it simply does not bear scrutiny. And notwithstanding clause as well is not often considered to repeal any and every law that would stand in the way of the later enacted law. The key case that the government has relied on actually uses the notwithstanding clause is in a contract. So it is referring to other language in that same contract. And that is an understandable use of a clause like that. However, here you have two entirely disparate regulatory schemes, and to import this notwithstanding clause back 20 years into a totally different statutory scheme is simply putting too much weight on that clause, particularly where there is a reading of the two statutes that allows them to be read harmoniously with each other.
Well, can I just, I will let this go in a minute, but what meaning do you think that clause has? Does it do any work at all?
Certainly, Your Honor. I think that it permits it permits the government's enforcement of mandatory restitution under the existing restitution scheme. So at the time that the MVRA was passed, there were several different types of restitution statutes that each operated in a different way. And I think that allowed, when Congress passed the MVRA, it allowed the new mandatory restitution scheme to operate even where there might be some piece of prior legislation or law that would have been a hurdle to what the new statutory scheme was intended.
Doesn't that describe ERISA, something that would otherwise have been a hurdle?
No, Your Honor, I don't think that's a fair reading of the notwithstanding clause, largely because it is not the case that the government cannot garnish funds that have been in an ERISA account. So ERISA protects funds in a retiree pension fund, but as they are coming out or and paid out to the defendant, in that scenario, the government actually can garnish the ERISA funds that are paid out to a defendant. And that's clear actually from the language of the Consumer Credit Protection Act. Which,
yeah, but that doesn't help this case because he doesn't qualify for withdrawals yet. He's in his 50s, and there would not normally be a payout. If he went in to his account, he'd have a penalty and otherwise have taxes. But I guess I'm not sure I understood your answer to Judge Harris's question. It's a pretty strong statement. It says notwithstanding any other federal law, and then it talks about all property or rights to property of the person fined. That's a categorically broad statement that sounds like Congress is trying to trump all the possibilities, including Social Security.
Your Honor, the use of notwithstanding is essentially too broad to carry the weight that the government is trying to place on it here. Congress.
Why is that? What does it mean otherwise?
Your Honor, Congress cannot upend ERISA with a vague statement in a later statute that doesn't even mention ERISA. And that's
well, it's not going to mention all the statutes. The code, the U.S. Code has tons of statutes, and Congress didn't want to go through and comb all of them, and also it wanted to cover statutes that it can't. The statute book is a dynamic thing, and what Congress is basically saying here, notwithstanding any of those visions, this trumps. That's what they're saying, isn't it?
Your Honor, I'm glad you mentioned that because, in fact, if Congress had intended to amend ERISA or
Not amend, just trump that clause in ERISA, which a non-alienation. Then Congress comes out with a statute that says, we say ERISA funds are not assignable, are not subject to collection on judgments, because we want to preserve that, with the exception of when the federal government has a debt. That's really what they're saying.
Your Honor, again, I think that, Your Honor, the idea that Congress would use that one clause to undo a significant piece of ERISA, to trump ERISA, which has...
what if they added, we mean what we say in this
one,
despite court rulings?
Your Honor, I don't think that would...
You seem to suggest that we shouldn't give it meaning because it's just one phrase and it implicates a bunch of statutes. So how are they going to phrase it differently? If their intent was to trump, give the federal government the ability to attach, garnish, or collect from any funds of any kind of any person, despite any other law, how would they say it?
Your Honor, I think they would mention ERISA.
Why ERISA? Also why not all the other statutes that are possibilities? I mean, there's all kinds of immunities, exceptions from levies, and all tools of trade, and workers' compensation benefits, and Social Security benefits, disability, pension plans of all kinds. There's the executive plans, plans involving options. I don't know quite how you would want them to do that if they wanted to refer to all statutes categorically.
Your Honor, to begin, I think they would mention ERISA, but I would also point the court to the later amendment of ERISA that Congress did only a year after passing the MVRA, and that is actually indicative of the complexity of the kind of amendment that the government's position says was affected with a notwithstanding clause. In order to make funds in an ERISA pension fund available to plans when the beneficiary had actually committed misconduct in connection with the plan, there is a lengthy amendment to ERISA that permitted the fund to offset that person's pension funds, and it took several pages of amendments to actually make that work. Because of the long-standing congressional protection for pension funds. And so I would point the court to that amendment as an example of how Congress would do it if it sought to. Judge Keenan this side.
Yes. Ms. Birch, you're really swimming upstream, though, in terms of the other circuits and where the analysis that they've engaged in. It seems to me like if you look at the Ninth Circuit in U.S. versus Novak, the court's very thorough in its analysis. It doesn't just rush to it. And it talks about the tax levy statute and how there's no principled basis to treat the language, to treat the tax levy statute differently from ERISA. I mean, what's wrong with the reasoning of the four circuits who went the other way? Tell me what's deficient about their reasoning.
I will do that, Your Honor. I would also just point to the Novak dissent. That was an en banc decision, and there are 5 judges that dissented on the same grounds that we're putting forth to this court. What's wrong with the...
Well, what that indicates is that your argument is perfectly reasonable, but it may not carry the day.
I understand it may not, but we certainly think it's the right outcome.
Well, that's fair enough. That's fair enough.
Thank you, Your Honor. Your Honor, to answer Judge Keenan, your question, the Novak decision, we don't think appropriately weighs what the Supreme Court has said about statutory interpretation, and that these 2 statutes actually can be harmonized. And I wanted to point quickly to the Social Security Act reference that's in the notwithstanding clause, because I think it's important. The government has pointed out that the Social Security Act reference must mean that the omission of ERISA doesn't mean that ERISA is not included. There is I see my time is out. If I may just
Yeah, you can finish that thought, sure.
Thank you, Your Honor. There's a significant difference between the Social Security Act and ERISA. And Social Security Act is a large general fund that belongs to all Americans, from which each beneficiary is paid out funds. Under ERISA, in the kind of 401k that we're talking about in this case, that is a set of earnings that Mr. Frank contributed into his fund and now sits there protected and accruing over time until he can take those payments. So there is no lump sum such as the government would seek.
Well, I'm not sure that's an accurate assumption, because I think it's included because the statute intends to get the property, all the property of a person. And Social Security, as you know, number one, pays out a lot more than people pay in. Number one. And number two, the money isn't all there, it's taxed yearly. And so people who write thoughtfully about Social Security, basically it's a welfare plan that whether you have a right to it or not might depend on the funds, but it's not a corpus of funds like a pension fund that they're just paying out. Anyway, I'm not sure that's worth debating on this.
If I may just very quickly respond, Your Honor.
Yeah.
The distinction here is that the government is seeking to alienate the corpus of the fund that belongs to Mr. Frank, that is sitting in the Schwab account. But the government could, under the current law, obtain garnishment of the payouts from that fund, just as it could under the Social Security Act and the other funds that are mentioned in the exemptions under the MVRA.
Okay, thank you very much. All right, we'll hear from Ms. Grimes.
Good morning, Your Honors. May it please the court, Laura Grimes for the United States. I would like to hone in immediately on this discussion that counsel was having with the court about whether or not these statutes can be held or can be harmonized with one another, and they can't. They're both talking about creditor rights. The 3613 describes the rights that the government has as creditor when enforcing restitution orders. And ERISA, on the other hand, limits the rights of creditors and says, no, you can't touch these things, full stop. Those are in conflict. If MVRA says yes, ERISA says no. And so in that case, one of them must yield. And as Judge Harris pointed out—
Why are they in conflict when Congress creates the exception and says we're now making an exception? In other words, it's not repealing anything in the ERISA plan. It's just trumping it with respect to a certain type of debt.
I believe that's—
Maybe it's semantic. Maybe that's semantic.
Yes, Your Honor. I believe we're getting to the same place, which is that the MVRA 3613 has said, notwithstanding any other federal law, and that sweeps it aside. To the extent that ERISA conflicts, it's swept aside. To the extent that they line up, that's fine. They can still be read like that. But if they conflict, the Supreme Court has said that the use of notwithstanding indicates which statute is supposed to trump when there's a clash. And this makes sense because when Congress enacted the MVRA, it wasn't just, as counsel suggested, to make restitution mandatory, although that's true. It was also to make sure, as this court noted in Grant and the Supreme Court noted in Dolan, and many, many courts have noted, it's to make victims actually whole, to actually get money back to victims. And in order to make that happen, Congress told the government, enforce these restitution orders, and gave the government really powerful tools to do so. And that's what 3613 represents. And every court to examine the issue has come to the same conclusion, that the language of 3613 clearly indicates that Congress intended to reach all property and rights to property of a defendant, just as if it were the IRS enforcing a tax levy. And it does that in several ways. First, it says all property and rights to property, which in the tax context has been held to mean, which is every interest in property a defendant may have. It says, notwithstanding any other federal law, which, as we discussed, means sweeps aside all contrary provisions. And then it also, just to make it more clear what it's saying, says this restitution lien functions as if it were a federal tax. And I don't understand there to be any dispute about the fact that the IRS can reach ERISA protected accounts when it's enforcing federal tax liens. And so the same is true here. The Congress very clearly employed language from the tax context that you must presume Congress knew had been interpreted to allow the IRS to reach ERISA accounts. And Congress then made the decision to use functionally that same language, in some cases exactly that same language, in this statute. And so the defense bears the burden here of demonstrating why these, an exemption applies. And it just can't clear that hurdle here because the statute clearly indicates that the government can reach all rights to property just like it says. And in terms, yes,
Counsel, can I ask you a quick question? And I don't want to get you too far afield too soon, but so the magistrate judge wrote an opinion agreeing with you on everything you've just said. But the magistrate judge said that as a result, the government can take the account, but with the exception of any tax withholdings by Schwab under the terms of the plan. And the terms of the plan say that Schwab will withhold 20%, and that the defendant in this case, or now the government stepping into the defendant's shoes, would only get 80%. So why is the government entitled to more than that?
Your Honor, I'm going to answer that question in several parts. But in the first instance, the plan documents also say that that the only permissible alienation is a garnishment or levy, a valid federal tax levy, I believe is the exact wording. And because the restitution lien functions like a federal tax lien, the government can come in under that provision. In terms of what the plan documents say, the government believes that the plan administrator is in the best position to determine what those plan documents mean, and that it might vary case to case.
In this case, is there any doubt? In other words, if the government has to, if the collection effort has to stand in the shoes of Mr. Frank, Mr. Frank, number one, has to pay a penalty. Number two, has to, according to the terms of the plan, turn over 20% toward taxes withheld by Schwab. And so in this case, I don't know which one's applied first, but in this case, if you had $100, Frank would get $70 if you added the two together. I don't know if that's the right way to do it mathematically, but let's assume 20% plus 10%. So out of $100, Frank would get $70. Seems to me the government should take $70 and give him credit for the $100 and turn over, let Schwab collect the 20% for the taxes and take the 10% and pay it to the Treasury. And that's if they're standing in the shoes. What's your response to that?
So I think that there is a distinction to be made between what the defendant's interest is in the property and what his liabilities are. He knew when he earned this money that he was placing it in a tax-deferred vehicle, and that eventually those taxes would become due. And that's what would happen here if the government were able to garnish the account.
Well, then you're saying that argument would also vacate the 10% penalty.
And that is, yes, Your Honor, and that is in fact what happened. The IRS has letters, and many courts have found that the 10% early withdrawal penalty is inapplicable when it's an involuntary withdrawal like that here, and in a tax levy situation. And so if that penalty doesn't apply to a creditor, the government is the only creditor that can reach it, to a government creditor reaching that money, it seems difficult to understand why.
Well, it wouldn't be reachable to the government. It would be reachable, it attaches to the asset. The government's looking for the asset, and the asset that Frank has is subject to the 20% withholding and the 10% penalty. And yes, so should the government get more?
So,
because if it gets more, then it imposes those duties on Frank. Now, at this point, Frank would have to pay all the taxes, probably, maybe he says 35%, but he has to pay the taxes on the withholding and he has to pay the penalty. So now the restitution is far larger with respect to him than the amount.
So first of all, it's held by, there are IRS letters, there are court opinions that 10% early withdrawal penalty does not apply in a compelled withdrawal like we have here. in terms of the taxes, if the 10% early withdrawal doesn't apply, it is difficult to see why defendant's tax obligation would apply to the government as creditor when the government seeks to take this money to satisfy a judgment. And again,
Counsel, can I ask you the you said two questions. I'll ask them both. One is that it looked like the Seventh Circuit in Syed said the contrary, that yes, you can get the lump sum because the defendant could get the lump sum too. So you stand in the defendant's shoes, you can get the lump sum, but you will take it, government, subject to the tax penalties faced by the defendant for early distribution of his retirement funds. So I'm concerned about breaking with another circuit on this. And I'm also concerned that the district court never looked at any of this, right? And I'm not exactly sure what happened here because the magistrate judge did say, like, you got to look at the terms of the plans, you have to figure all of this stuff out. And the district court didn't. The district court instead granted this sort of 10% matter of equity kind of allotment to the defendant. So one possible solution, it strikes me, is we could send this back to the district court and tell the district court to look at the IRS letters and figure out, if the government gets what Frank would get standing in Frank's shoes, let the district court figure out what that amount is.
Yes, Your Honor, and that would be a possible outcome. We do think the record here is sufficient, though. If the plan administrator is supposed to determine which provision is applicable, whether it's the tax levy provision or the 20% withdrawal provision, it seems like the plan administrator would be best situated to do that and determine what happens in this case and every other case. There, I think, are policy arguments on either side. Yes, Your Honor.
Yeah, why would this be an issue for the plan administrator? Because what we have here is what is the reach of the restitution statute? That's a legal issue.
The government,
Judge Harris is saying, to be determined by the district court in the first instance. That's a legal question as to the reach of the restitution statute, not how the plan should be administered, isn't it?
Yes, Your Honor. And the district court did reach it. The district court determined that Mr. Frank has a right to the entirety right now. He also has attendant tax obligations because of his choice to put the money in the account. And the district court determined, as Judge Harris said, as a matter of equity, that it would give effect to the government's settlement offer to give defendant 10% towards any possible future tax ramifications. I think there are policy arguments on both sides. On the one hand, it seems terribly unjust and inconsistent with the MVRA to pass on the tax consequences of defendant's choice to put things in a tax-deferred account onto the victim.
Oh, you can't hold him responsible for that. That's a choice he made early on before even having the restitution argument. He decides where to put his money, whether it's in a savings bank or in a pension plan or under his mattress. It seems to me the government takes whatever assets he has in their present state. I mean, the fact he made a choice 20 years ago when he was working with a company to participate in the pension plan, I can't see how that's relevant at all. You take his assets the way they are today. And if they're under the bed in the form of gold, I suppose you can take them.
Again, the distinction that the government drew below and would make now is that there is a difference between his interest in the property, which is in the whole.
Well, sure there is, but he defined that. That's what he chose to give up and what he chose not to. He could have paid taxes back in a form of plan when he initially put the money in and put in after-tax dollars. Most people like to let the plan accumulate and defer the taxes. But that choice is an economic choice that defines the nature of the property. And in this case, he made that choice legitimately, not connected with anything in this case. And he now has pension money, a lump sum pension money that's subject to taxes. He shouldn't get penalized. There's no basis to go back and say he made a choice and therefore you don't, you add on to what he has to pay. And that's essentially what the government's position. We're going to make him not only turn over the assets in there, we're going to tell him he has to pay taxes, which he otherwise would not have had to pay.
Your Honor, he would have to pay those taxes.
Well, he'd have to pay the income taxes on a deferred basis later.
Yes, Your Honor.
But the penalty taxes, you're saying he doesn't have to pay now?
The 10% is inapplicable. So he does not have to pay. No one will be paying that now. And I think there's a reason for that.
Will there be a 10% levy at any time?
My understanding of the law is no. Standing here today, I do not.
Why has it been given then in this case?
That was a settlement. I'm sorry, Your Honor. That was a settlement offer the government made in the interest of settling the case before litigation. The district court thought it was fair and decided to let it play out, and the government didn't challenge that.
That's sort of strange, isn't it?
I think on balance, the government believed that it was a fair outcome.
I understand that, but we're supposed to be determining how much money can be attached by garnishment.
Correct.
And so is there a notion that we're enforcing a settlement in this case?
No, I don't think so, Your Honor. The district court has
the district court wasn't bound by any settlement agreement, was it?
No, Your Honor. No. That was in her judgment. She thought that was an equitable resolution, and the government didn't object. If I may, I would like to move on to the Consumer Credit Protection Act, unless there are more questions.
I'm sorry, just if you're ready to move on, I just want to make sure I understand where we are on this 10% penalty. I mean, was this briefed? Should we just take, is it your position on behalf of the government, I guess? Is the government saying now to us, there will be no 10% penalty, do not worry about that? And you can make that so?
I don't speak for the IRS, and I cannot, but there are many cases, there are IRS letters, there are lots of IRS guidance. If you Google IRS tax levy 10% withdrawal, and
well, maybe you could send us some cases. That's the way we usually do it. I mean, if you want us to rely on this, it's not briefed or anything, right?
No, yes, Your Honor, it is.
Okay, it's in here?
Yes, Your Honor.
Okay.
So may I move on, or do you have any more questions?
Yeah, no, as long as we have your position on this, okay.
Yes, Your Honor, it's in the papers. Returning to the Consumer Credit Protection Act, the defendant's argument is essentially that because the money deposited into the 401k originally had as its source the defendant's wages, it has retained that while the plan kept it in trust for the defendant to be distributed at a later date. And that just doesn't work with the way the Consumer Credit Protection Act defines earnings under the statute. It says, wages, paychecks, bonuses, and also includes periodic payments from pension and retirement plans. And the statute itself is doing a lot of work here. By including the periodic payments, there is a strong implication that Congress intentionally excluded non-periodic lump sums like we have here. And that conclusion is further bolstered by looking at the nature of the property here. And Kokoska is controlling. Kokoska talked about how not everything that has its source in wages retains that quality. And in that, the court there pointed to savings accounts and automobiles. And then the tax refund that was at issue there. This situation is much more akin to a savings account than it is to regular wages. The Kokoska court noted that the point of the CCPA was to protect periodic payment of compensation needed to support the wage earner and his family on a week-to-week, month-to-month basis. And that's why the statute says what it says. It sets payment for personal services such as wages, bonuses, and also these periodic payments. Here, defendant took his wages, he essentially put them in an investment or savings vehicle. That money, his employer matched contributions, the money was all pooled together, it's been invested in the market. The present value of that account is $673,251. That money, he can pull it out at any time, yes, subject to penalties under the plan if he were to voluntarily withdraw. But he has control here. This is no longer payment for personal services. This is just his money. And once that happens, it's no longer within the realm that the CCPA is meant to protect. It's just like the savings account that the Kokoska court mentioned.
I'm sorry, counsel. I can't find the part about how their IRS letters saying that the 10% withdrawal penalty won't be imposed in a case like this, but that is briefed in here. I do apologize. I can't find it.
Your Honor, I would need a moment to find that.
I mean, it just seems like a tax law question that I'm not expert on, but.
Yes, Your Honor, I'm trying to find the section where we quote to, oh, I know where it is.
I'm sorry, you can.
I have nothing further and would rest on the papers. And so if I could use the balance of my time to find it, I'd be happy to do that.
No, it's okay. It's all right.
And the government rests on the papers if there are no further questions.
Okay, thank you very much. Okay. Mertz?
Thank you, Your Honor. Your Honor, the questions that have arisen regarding this situation with the tax, whether or not the tax would be assessed, whether or not the plan administrator would make the decision on whether or not to withhold the 20% or how much to pay out. These are all exactly the kinds of questions that you would expect Congress to have addressed if it were going to have the MVRA trump this portion of ERISA. So we would just point to that confusion and the lack of clarity as further evidence that that was not the intent of Congress in enacting the MVRA. I wanted to just point to the language tax levy, which the government has employed, versus tax lien, which is what is actually authorized by the MVRA. The MVRA, section 3613, refers to the creation of a tax lien. A tax lien is not a tax levy. And a levy is an enforcement mechanism, essentially. But it creates a lien as if these things were tax liens by the IRS, but it actually does not say that that's what they are. What the plan permits is alienation in only two circumstances, involuntary alienation in two circumstances. One, a qualified domestic order, or two, in the event of a, quote, proper IRS tax levy. And the piece of law that the government is referring to that permits the avoidance of that 10% penalty is only when there is an actual IRS tax levy. So again, it is not at all clear that that 10% amount would be avoided. The language is not clear, and to leave it up to the plan administrator would really seem to illustrate that ERISA is not intended to be trumped.
I understand you to be arguing that with respect to the, if we were to agree that the government could reach monies in this plan, I gather you would prefer to have the district court address the amounts, 20%, and the 10% issues.
I think there probably is room for further fact finding in this case. The plan documents, I believe, would control what Mr. Frank actually has a right to, and it is clear from the plan documents that he has a right to no more than 70% by the terms. But there are additional tax.
Well, the 20% the district court didn't even address, did it?
Correct, Your Honor. That's correct. Just to move on to the Consumer Credit Protection Act, unless there are other questions about these issues, the government is performing something of a rhetorical sleight of hand. The money in the Schwab fund was earnings going in. There's no question about that. It was deferred earnings going in. And if it were being paid out, it would be earnings. The Consumer Credit Protection Act makes that clear.
I know, but at some point, you know, the difficulty is the typical protections throughout both federal and state laws is to let a person take home a portion of his paycheck. And so there are all kinds of exemptions that provide that when a person earns $100 a week, he can take home some of that money to pay for shelter, food, etc. And garnishment in the hands of the employer means that the employer will take 20% toward the debt and 80% to the employee. The employee takes the 80%, or the employee takes 100% of his earnings and takes a portion of them and puts them in a savings account. That was earnings, but now it's savings. It's no longer even fits the structure of what's being protected. There is an exception with respect to a pension plan. When you get to you've retired and the pension plan keeps paying you 60% of your salary for the rest of your life, that, according to the section 1672, would also be subject to the exemption. But here, this defendant accumulated a savings account, so to speak, a lump sum of savings account. And while he did so from earnings, they are not now earnings, they are saved money. And it seems to me, it's an interesting line to try to draw, but it seems to me that's a little bit what 1672A is trying to get at, isn't it?
Your Honor, respectfully, I disagree. And the reason is this, and my time is out, if I may respond.
Please.
Thank you, Your Honor. If Mr. Frank had taken these funds and put them into a savings account, when he took them out of the savings account, he would owe no taxes on them because he would have paid that. But these are deferred earnings that are sitting in a protected account that have never been taxed. They remain earnings. If he were to,
I mean, there's all kinds of taxable and non-taxable vehicles these days. You can buy municipal bonds, and you can go into various savings plans where you pay taxes up front, but then there's no taxes on the earnings. You can put deferred tax plans and so forth. How you save your money seems to me isn't a question of whether that money is compensation for personal services. The compensation for personal services is the compensation paid by the person receiving those services to him. And as in any attachment or garnishment, there's a limitation on how much of that money you can take. And I think that's what this honors.
Your Honor, if I may, this is compensation for personal services, and it is treated on all sides. The beginning when it's going in, if it were to come out in a lump sum now, or if it were paid out periodically at a point where he began withdrawing, it would be treated as earnings in each of those scenarios. So even if he were today to exercise a voluntary option to liquidate the fund, it would be taxed as earnings and treated as earnings by the IRS.
Okay.
So it is not lost its character simply because it's sitting in the fund.
Thank you.
Thank you, Your Honor.
This is an interesting case, and our normal practice would be come down and shake hands with both of you for your good arguments and welcome you to the court. That's a tradition that goes back to Judge Parker in the 1930s. It's a lovely tradition which we have not given up, but as you know, we're prevented from doing so now. So we greet you on behalf of the court, and this will have to suffice at this point.
Oh, and Ms. Grimes, normally when I came down to shake your hand, I would say I found that part in the brief, and I apologize for the confusion.
Very good, very good. Okay, well, thank you very much. We'll take a 5-minute recess, and the judges will meet in the roping room, and lawyers can go home and have lunch.
Thank you.
Thank you.
This honorable court stands adjourned, signed and died, God send United States in this honorable court.
I'm gonna go.